Welcome to the Legal Roundtable Back to School Edition. I'm Shenequa Gray. Tonight on the Legal Roundtable, we're talking to the superintendent of Louisiana's Recovery School District about their efforts to improve the education of students in underperforming schools in Louisiana, and in particular here in East Baton Rouge Parish. We'll also hear comments from the Vice President of the East Baton Rouge Parish School System, Mr. Tarvel Smith. And then later on the Legal Roundtable, we'll be taking a closer look at Louisiana's voucher program, and in particular, Brian Blackwell, who represents the Louisiana Association of Educators, who has filed a lawsuit against the state of Louisiana and other parties, challenging the constitutionality of the program, will be here explaining those constitutional issues for us tonight. So it's all about education tonight, right here on the Legal Roundtable. Welcome back to the Legal Roundtable Back to School Edition. In this segment, we're talking about Louisiana's Recovery School District. And our guest is the superintendent of Louisiana's Recovery School District, Mr. Patrick Dobart. He's the former deputy superintendent of the Recovery School District and was named the superintendent in January of this year. And we also have Tarvel Smith, vice president of the East Baton Rouge Parish School System. He's been a member of the board for 8 years. Welcome, gentlemen, to the Legal Roundtable.
Thank you.
Mr. Dobart, let me begin with you. Could you explain what the Recovery School District is? Because I understand you all are doing great work in Louisiana to help these underperforming schools. And could you tell us what this is?
Yeah, absolutely. So the Recovery School District is an arm of the Department of Education, where we were created to basically transform, we're the state's turnaround engine. So we transform underperforming schools and hopefully turn them around on a path to academic success. And so right now we have about 77 schools throughout the state. Most recently, we've taken over control of 7 schools in the East Baton Rouge area.
Okay, and could you tell us about some of the strategies you all use to turn these schools around?
Yeah, absolutely. So basically, when we first take over schools and direct run them, the main thing we do is want to stabilize the schools, bring in strong educators, leaders of the school. But more than that, what we do is then we go out and recruit high-quality charter providers to go and run the schools in an autonomous manner with high accountability. And what we do is just hold them to these high standards, would allow them to implement programs and things that they deem to be successful. And then upon 3-year and 5-year windows of their contract, we review to see if they met the goals that they've set. If they have not, we either give them an extension with some probationary terms in it, but otherwise we may shut down the charter and then seek out other charters. And so that's our main strategy, is to go in, stabilize, and then charter schools.
Okay, now obviously you all focus on underperforming schools, so these are schools that have earned a grade of F for 4 consecutive years, right?
Yes.
And that's an automatic takeover by the Recovery School District?
Well, not automatic. So what it is, you have schools that they've been deemed academically unacceptable for 4 or more consecutive years. And then once that happens, that means that they're eligible to come into the Recovery School District. And so the state can go in, and then we've had different arrangements. Some schools we've gone in and directly controlled them at that time. Some schools, unfortunately, languish for more than 8, 9, 10 years as academically unacceptable schools before the state intervened. But once the decision is made to intervene in the school, then the state does come in and retain jurisdiction over them.
And now also parents can petition to have the school transfer into the Recovery School
That's
District.
That's correct.
Well.
So there's a parent trigger option that was passed in law this year, and so it does give parents the ability to, if they get a petition of over 50% of the parents, to opt into the Recovery School District. And that could mean also to opt into bringing in alternate providers to come in and take over the schools.
Okay, now, Mr. Smith, you're obviously a member of the school board, and you have many of the schools, all of the schools that are in East Baton Rouge Parish has been formerly within your jurisdiction. Could you tell us a little bit about how the community has been receptive to the work of the Recovery School District? Because I understand there was quite a bit of controversies around this recent Estruma High takeover. So what are the people saying in Baton Rouge?
It's been a mixed reaction, and I believe that the people in Baton Rouge has seen what has gone on over the past 4 years or so. They have not seen the rapid improvement that the Recovery School District has said that was going to happen to the schools. And what's actually happening on the ground, the kids that normally would go to those schools that were under East Baton Rouge Parish jurisdiction are choosing to return back to East Baton Rouge parish school system. So it's been a mix. You have some people in the community that are saying, okay, we want to give this a try. And then on the other hand, you have some that are saying, well, I have not seen the growth that was promised, and I'm comfortable with something that I know, which is the East Baton Rouge Parish School System. So you have a mixed bag.
Now, Mr. Dobar, many of these schools are charter schools, and some of the schools who aren't are being converted into charter schools. What is it about charter schools that you all find to be more effective than a traditional public school?
I think the biggest thing is what we always describe as sort of the decentralization of power. So what charter schools allow you is to have, they are basic, think of a charter school as its own education agency. Think of them as their own EBR board. So they have their own independent board, but all of the hiring and firing decisions are done by the school leaders. So those closest to the kids make decisions that affect children. And so they control their budgets. They make decisions just, again, at a school-based level. And so we found that to be successful. Just for example, in New Orleans, only 6 years ago, 23% of children were scoring at a basic and above level on our state assessments. Move forward to this year, for the first time, over 51% of children in New Orleans are scoring at a basic or above level. And that's with a majority charter school district. And it's not to say that charter schools are the be-all, end-all, but what it is, it has shown to be a proven strategy, and we're trying to replicate that not only in New Orleans, but around the rest of the state.
Well, let's talk a little bit about this achievement zone, because some of these schools, about 7 of the schools that are part of the Recovery School District, are part of an achievement zone here in Baton Rouge, where you all are focusing your energies in order to help improve those schools. What plans do you all have for this achievement zone to help improve them?
Well, and I appreciate you asking. So the achievement zone was something that came out when we looked at like the largest percentage of failing schools in the East Baton Rouge area. They all fell into a 3 zip code area that comprises what we all think of as North Baton Rouge. And so we wanted to think about what could we do dramatically different to transform those schools, but not like to community, but with community. And so what we've done is we've created a zone, and what we're trying to do is bring in partners. And it's not traditional. It's not that we have this money and things to bring in partners for them to provide services. It's quite the opposite, where we're looking for individuals to bring services and expertise to give into the zone. So whether it's social work help or whether it's wraparound service for after school care, to come to the zone, bring resources. We've looked for partners like Entergy, who's been on board, and others who we want to come in to help incentivize schools to turn around and be higher performing schools. And we've even reached out, and EBR has been receptive to the fact that they can charter schools out themselves, because a local school board has the right to charter schools. And we've been in discussions. They've been very open-minded, because we all want the same thing. We want to see these schools turn around. And so for them, it's a matter of, what resources can we as the state put in the achievement zone that would help them as a school board to be incentivized to come and be a partner in the zone. And so we're looking forward to building resources, creating incentives to bring in high quality charter providers, as well as other resources that we know will turn our schools around.
Okay, and has the East Baton Rouge Parish School System been supportive of the efforts of this the Recovery School District, Mr. Smith?
We have had ongoing talks. We've been receptive, and given state law, the trigger that causes some schools to fall into their jurisdiction with a vote of Bessie, there's not much we can do. We're pretty much divested of jurisdiction once a school goes into the Recovery School District, or which is this new achievement zone. We want to work hand in hand with the state to see that kids are getting the best quality education, be it charter, traditional, new voucher, whatever the case may be. To make sure that the child as a whole is educated the best way that child can be.
Thank you both for being on the show. I really appreciate you coming. And we'll be right back in just a moment with more of the Legal Roundtable Back to School edition. Stay with us.
If you're a lawyer and you would like to be a guest on the Legal Roundtable TV show, call Shenequa Gray at 225-772-1819 or email to the Legal Roundtable at Hertzock.com.
Welcome back to the Legal Roundtable Back to School edition. In this segment, we're talking about Louisiana's new voucher program that was significantly expanded during this past legislative session, and it goes into effect during this 2012-2013 academic year. And helping us to address some of the key issues surrounding this program are Mr. Steve Monahan. He's president of the Louisiana Federation of Teachers, one of the organizations who opposes the voucher program, and has filed suit against the state of Louisiana and other parties challenging its constitutionality. We also have Mr. Eric Lewis, president of the Black Alliance for Education Options, an organization that actively supports educational options programs such as the voucher program, and who in July of 2012 was allowed to intervene in the pending lawsuit filed against the Louisiana and other parties challenging the constitutionality of the program. Welcome, gentlemen, to the Legal Roundtable.
Thank you.
Thank you both for coming, because as you all know, this issue has been the subject of very much debate since it's been passed, and it has even garnered national attention. So I appreciate you all coming here to talk about some of these issues. And I'll start with you, Mr. Lewis. Your organization, the Black Alliance for Education Options, actively supports programs such as this, and I also would say you support expansion across the entire country. Could you tell us a little bit more about your efforts to implement programs such as this?
Yeah, we've been in Louisiana in particular since 2008, which actually was the same time that the pilot program was launched in New Orleans with about 640 kids. And from day one, while it was a small program, after that first year, parents from out the state, through Jefferson Parish and beyond, kept asking, why couldn't they have this in their community? And even as late as last year, we had a number of parents in Baton Rouge and in Shreveport at different town hall meetings asking to have this program brought to their communities. And so our organization supports the ability and the power for parents to choose the best quality learning environment for their child. And so we think that the scholarship program is one venue to do that. When you look at Act 2, there are several other components in Act 2 that allow parents to have power to choose a quality education for their child. And the reality is that if you look across the state, for far too long, that has not been the case in many communities in this state.
Okay, well, Mr. Monahan, now we know that your organization, the Louisiana Federation of Teachers, obviously opposes programs such as this. And could you tell us what's wrong with the voucher program, in your opinion?
I think you started with the right in the right frame, because you called it what it is. It's a voucher program. It is not a scholarship program. There is no scholarship attached to the program. I can give it to you in three simple reasons. One, we are philosophically opposed to the issue of vouchers, because I think the emphasis of the state should be on providing quality education to all children, regardless of where they attend school. That means there must be accountability in the process. That means we must have quality assurance. That means if we're not doing this for all children in all public schools, then we do not have to we should not be diverting money to schools that we aren't holding accountable. The second piece has to do with specifically Louisiana in Act 2. The process by which that bill was passed and became law, there is no other word to use except to say it was offensive. If the bill would have been thoroughly vetted, as the bill, it's 45, 47 pages long, the voucher piece of the bill doesn't appear until page 30 of the Act. It was railroaded through. The third and final piece is the Constitution. We should, as a people, respect the Constitution for what the Constitution says, what it means. Now, Mr. Lewis is correct. There was a voucher pilot in New Orleans in 2008. Pilots connote that after a pilot, you assess whether the pilot's successful, whether it's produced the results that you'd like to see it produce, and that the product is actually superior to what children were receiving before. What was absent in 2012 when we had the debate was any statistics, any assessment of pilot. So essentially we expanded on a program that we have no evidence that it's produced anything in regard to the improvement for children in those schools.
So let's address one of those issues, or a few of those issues, but let's start with that one first, Mr. Lewis. What about that? Do we know that these types of programs are effective?
Well, here's the deal, and I guess it's a matter of what you're looking for with regards to results. Because when we look at this and we look at parents whose kids enter this program in kindergarten who ordinarily would have gone to schools in New Orleans that were the most abysmal in the country. Okay, and so our organization, excuse me, again, is focusing on giving parents the power to choose. And so from 2008 until this year, the program maintained a 95 to 97% satisfaction rating from the parents that participated in the program. So that tells us that the parents are happy with the program. The retention rate has been outstanding. And when we compare that to possibly the dropout rate and the migration rate of our public schools, there's a drastic difference. Now, I will say that, you know, because I know this is where we're going with this, that from an accountability standpoint, there was tremendous room for improvement in the accountability program. And, you know, our organization believes that children should have access to high-quality options. It's not a matter of taking them from one failing situation and moving them to a different failing situation.
Okay.
And so I would say that we have made strides in that regard as well.
Now, that brings me to my next point. You say high-quality options, and I think that has been another main concern, which is the adequacy of some of the schools that we're dealing with. I think there have been reports in the media regarding certain facilities not having sufficient facilities for the students that they've had, not having sufficient teachers, technology. There was criticism of the Louisiana administration for not doing due diligence in the initial review process, although I believe that has subsequently changed. Is it the idea that if the parents get to choose, then it's okay no matter what type of education they're getting? No,
I wouldn't say that. For our organization, I mean, first and foremost, we have to give parents the power to choose, which they don't have currently before this legislation. In many places across the state, they did not have. Now, secondary to that, you know, our organization will not stand by again and allow parents to go and leave failing situations and move into failing situations. I think what we've seen through this process, while there's always room for improvement, I think that what we've seen through this process, actually 2 of the schools that were initially on the program have been removed. There were other schools that applied, and this did not get as much public attention, but there are several other schools that applied that were not allowed to participate in the program. And so there are some rules that have been set in place, and there's some processes that are in place that had not been in place with the pilot New Orleans program. I mean, there's some chinks in the armor, and there's some room for improvement. But I think, again, we've made strides far beyond, for parents and for kids, we've made some strides far beyond what many have had. There's a number of communities throughout the state where the only option the kids had was that one option in the neighborhood school down the street from them that has not been producing positive results. And so I would venture to say that parents can tell you that this has made a difference in their lives.
Okay, now, Mr. Monahan, you initially brought up the issue of accountability, and we know that there has been some criteria that has been put in place. And just to say a couple of those criteria, students will take the same standardized tests as public schools, although they will not be held back if they do not pass. School is required to report only if more than 10 voucher students are taking the test, or 40 voucher students in all testing grades. If it's 40 voucher students or less, no penalty for poor performance. If it's more than 40, then the students get this numerical grade, and depending upon what that numerical grade is, there may be some penalties, but we know that much of this is subject to be waived by the superintendent. I think you were quoted as calling some of this criteria as a sham.
I would call the whole thing a sham.
Okay. What are your thoughts on that?
Because the process has been offensive since the process has begun, and that is not Mr. Lewis's fault. Mr. Lewis has an objective, and that is, he has indicated very clearly they are a voucher organization. They say options, but essentially it's for vouchers, and that's fine, and I respect him and I respect his motives. However, I don't respect individuals that short-circuit process. There was less than a 24-hour notice when those rules were released. We're now struggling with the Department of Education to allow for the public to input the rules according to the Administrative Procedures Act, 90-day review. We've yet to see the rules be published in a Louisiana registrar. You hit on it, Ms. Gray, right without even discussing the rest of the story in regard to those accountability rules. They all can be waived. I did a word count on the number of times the word may is used in those policies. If we were concerned with quality and accountability, it would have been built into law and not as an afterthought after we heard of stories of the Loch Ness Monster in some schools and the Ku Klux Klan and other books being used as good history. Now, Mr. Lewis has nothing to do with that. But all I will say to Mr. Lewis and conclude with all due respect If we were to judge the public schools' performance on the warm and fuzzy index, is what it is, the smiley faces, 94 and 95% satisfaction rating, without labeling the schools with a label that predisposes the public to a position. Schools are reflections of communities and the wants and needs of those communities. I think Mr. Lewis and I both agree. Our homes are under-resourced, our families are under-resourced, and our schools that we're looking for escape from, and this is where it bothers me the most, Eric, it bothers me the most. Top-tier schools that are acknowledged to be the big ones, where the money is spent, they're not on the list, but they have 1 seat or 2 seats. That's not access. That's a sham.
And that is a relevant factor. And you also mentioned something else, which was this issue of curriculum. That has also been a criticism of the program as well. You have some people complaining for the most part about not wanting to support certain types of programs, such as religious programs. And then it also brings this issue up of whether that curriculum is adequate, because I know that there have been reports of people supposedly having, using DVDs for instruction. So curriculum is certainly another issue. But what about this effect on public schools, Mr. Lewis? That is also another question, because we know that as this program is set to expand to possibly all eligible students, we could be looking at, close to 400,000 people potentially leaving public schools. And so what effect does this have on public education? I mean, is this an effort to privatize education?
Well, out of all due respect, I would say it's that number 400,000 would be eligible.
Okay, right.
The reality at the end of the day is we don't have 400,000 seats, and not every child is going to leave the public school system to take part of this program.
Right.
The other thing that we have to understand when we talk about parental choice is giving parents the opportunity to choose, and that could be within the public school system. It could be charter schools, it could be virtual schools, and so I think the conversation has to be changed slightly, in my perspective. What I also would say is that I think, unfortunately, my friend, too often, the conversation is about buildings, it's about jobs. I agree with him completely on the accountability concerns.
Right.
But too often when we talk about the financial impact, it's about buildings and jobs.
Well, it seems like you all are in agreement on some major issues, though, but this is not finished by any means. We know that it's also set to go in the courts, and in the next segment we're going to be talking about the constitutional issues surrounding it. So I do appreciate you all coming. I know there's a whole lot more to be said, but that's all we have time for, so thank you all for coming.
Thank you so
And
much.
that's all we have time for in this segment. We'll be right back with more of the Legal Roundtable in just a moment. Stay with us.
If you're a lawyer and you would like to be a guest on the Legal Roundtable TV show, call Shenequa Gray at 225-772-1819 or email to the Legal Roundtable at Hertzock.com.
Welcome back to the Legal Roundtable Back to School edition. In this segment, we're continuing our discussion of Louisiana's voucher program that was significantly expanded during this legislative session. And in this segment, we're focusing on the constitutional issues surrounding the new program. And our guest this evening, helping us to explain these issues, is Attorney Brian Blackwell of Blackwell and Associates. He's an attorney representing the Louisiana Association of Educators in a lawsuit filed against the state of Louisiana, the Board of Elementary and Secondary Education, and the Department of Education, challenging this program on several constitutional grounds. He's been practicing education law for almost 25 years. Welcome to the Legal Roundtable, Mr. Blackwell.
Thank you.
And thank you for agreeing to come on the show. These are important issues. A lot of people obviously are interested in this program and would want to know what's going on with it in courts. Just say if it is not upheld, they want to know basically why. So thank you for explaining these issues. Now, could you first explain to our audience what is the minimum foundation program of education, or this per pupil amount that these schools could potentially be receiving on behalf of the students? Could you tell us a little bit about the authority for it, as well as the sources from which this money is derived? Because it seems like a good understanding of that issue is important to the constitutional issues involved.
The minimum foundation program is created by Article 8, Section 13 of the Louisiana Constitution, and basically it requires that the Department of Education and VESI every year come up with an amount of money that in their view is a minimum or a floor for the education of students in Louisiana. That formula is then submitted to the legislature for approval, and it's either approved or not approved. And the amount of funding varies widely across the state, and is the components of it include a state portion and a local portion, and that local portion is derived from both property taxes and currently sales taxes.
Okay, does the Constitution really speak to what that money is supposed to go towards?
Well, the Constitution only refers to public schools and public school students, public schools. It doesn't refer to anything else, and so the presumption is that when it says public schools, it means public schools.
Okay. Now, one other issue that I think is important to understand as we get into these constitutional issues is the fact that we are dealing with two different instruments. Obviously, one is Act 2, which established this voucher program as well as some other programs as well, I understand. But also we're dealing with this Senate Concurrent Resolution 99, which sets up the funding for the program. And I understand that the constitutional issues you all raise deal with either one or both of those instruments, depending on what it is.
That's correct, and I think the easiest way to understand it is Act 1 creates the programs, and Senate Concurrent Resolution 99 funds the programs.
Okay, and it seems like that brings us to this first constitutional issue, because you all are challenging both of those instruments, basically claiming that, as you just said before, the Constitution said that money is supposed to go towards public education and not private education. Is that correct?
That's correct. The Senate Concurrent Resolution 99 has been challenged on several bases. There's one provision in the Constitution that requires that instruments that are intended to have the effect of law be introduced not later than the 23rd day of the session. In this case, Senate Concurrent Resolution 99 was introduced on the 30th legislative day of the session. And the reason for requiring that deadline is obviously everyone needs a deadline to do things, otherwise things will happen on the last day of the session.
Right.
And we need time for people to be able to thoughtfully consider legislative instruments before they're required to vote on them.
And now there's also another procedural issue you all raised regarding Senate Concurrent Resolution 99, don't you?
Yeah, the other one is that the Constitution requires for passage of a bill a vote of a majority of the people who are elected to both bodies, both the House and the Senate. And in this case, Senate Concurrent Resolution 99 received less than a majority vote. They only received 51. A majority would be 53. And therefore, it's claimed in the suit that that resolution really never became effective because it never had a majority vote.
And both of those procedural issues will, I guess, a major concern would be whether or not they actually have the effect of law, because the law is clear that it says that it's no new matter. It doesn't require that it be a bill per se, but it has to be a matter having the effect of law.
That's correct, and I think the use of the term matter is very important, because matter implies that it's something more than a bill.
More than a bill.
Otherwise, the people would have said bill, and I don't have any doubt that it's intended to have an effective law, because the concurrent resolution spends $3.4 billion tax dollars this fiscal year, and I would think that the legislature is just not willy-nilly passing resolutions of that magnitude.
Right. Now, moving on to the next issue that you all raised, dealing with multiple objects. This only applies to Act 2, and the law requires that a bill only have one object, but this one apparently has more than one.
Right, and this bill deals with so many subject matters that in addition to dealing with voucher schools and private schools and parochial schools and online schools and home schools and everything else, it also has a provision in it related to how courts are to give preference in the determination of the constitutionality of the act, and that's clearly not related to school choice, if you will, even if all the other ones can definitely fall into that category. So it definitely has more than one object.
And I can understand the reason for that requirement, because obviously a legislator needs to know what he's voting on, and some of these are very different, and a person could certainly have different views on some of these different objects and not necessarily want to vote the same way on all of them. And so even if they're falling under this school choice characterization, it certainly seems that they probably could have been separated in some way. And then you have another couple of issues that you raise, and another one deals with the diversion of these local funds. Tell us a little bit about that.
Right. The school funding in Louisiana, as I said, comes from sources of state funding and local funding. The local funding is derived from property taxes and sales taxes. And those property taxes include what's called a constitutional tax. That is, everyone around the state pays that. But for the most part, most of the local money is derived from us voluntarily taxing ourselves, either through agreeing to do it through property taxes or agreeing to do it through sales taxes. And those taxes generally are dedicated to a specific purpose, such as teacher raises in the public schools. And the constitutional challenge is that that money can't be used for a purpose other than the voters permitted it to be used for. The way that the legislation attempts to sideswipe that concept is really through a shell game of saying we're not giving you as much, but we're not taking anything from you.
Right, exactly. And then the final constitutional issue is, as we started out saying before, it just deals with the fact that the Constitution speaks specifically to what these funds should be used for, which is public education, and doesn't mention these other grounds.
Right, and the Constitution only gives Bessie the authority for budgetary authority over public schools. It gives Bessie no authority to budget money for private schools. The MFP constitutional provision, Article 8, Section 13, doesn't refer to private schools, it doesn't refer to parochial schools, it doesn't refer to anything other than public schools and city and parish school districts.
Right.
And it's our belief that that clear language was intended by the voters to mean what it says.
Okay, now I know that there's this argument, though, that does the money follow the student or does the money follow the school? And I guess the argument is that provided you are paying the tuition of a person who would be in a public school, then it's okay. Do you think that could possibly be construed, that the Constitution could be construed to just require the payment of a public school student's tuition wherever the school may be?
Well, I don't think that's what the voters intended when they passed the Constitution. Otherwise, they could have very simply said that. They could have said, we'll give every student $5,000, they can spend it wherever they want to.
Right.
We didn't do that.
They didn't say that.
We didn't do that. What they said is we're going to make this program to establish a minimum foundation for public schools. And I think that's very significant in this case.
Well, those are the constitutional issues that are raised and that the court will be deciding, and that will be in October of this year, correct?
That's right, October 15th.
Thank you very much for coming. And thank you for joining us for this edition of the Legal Roundtable Back to School. You can always keep up with what's going on with the Legal Roundtable at the blog at www.thelegalroundtableshow.com. Till next time, I'm Shenequa Gray.